The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. The first case we'll be hearing is Rev Valve Inc. et al. Versus Titan Valve Inc. et al. I understand that counsel for both plaintiff and defendant will be splitting time with co-counsel. I will allow you to keep up with your own time and just transition seamlessly. That being said, we'll hear from the appellant.
Thank you, Mr. Chief Justice. Associate Justices, may it please the court. My name is Josh Durham. My law partner, Ward Davis, and I represent the appellants Titan Valve, Fabian Ado Ortiz, and Ben Payne. We are appealing the Business Court September 3rd, 2019 second sanctions order, which struck our client's answer and entered default against them. And then in connection with that, entered an order of September 5th, 2019, imposing monetary sanctions against them in the amount of approximately $246,000. I will be addressing what we view as the main procedural defects that we are challenging, giving rise to those orders, namely sections 1 and sections 2A and 2B of our brief. I'll refer to those as the reply evidence and the incorporation evidence, as well as section 4 regarding the temporary restraining order that was used as a further basis for the sanctions order. Mr. Davis will then address how our appeal relates specifically to Ben Payne, which is sections 2C and 3 of our brief. I'll take roughly 15 minutes. Mr. Davis will take roughly 12, and we'd like to reserve 3 minutes for rebuttal. Although in Mr. Davis's section, depending on how much of his ground I plow, in my section, we may have some additional time for rebuttal that will leave, but Mr. Davis will make that call during his presentation. When announcing its tentative ruling from the bench, the trial court below said that the conduct it had seen in this case amounts to the worst disregard of the judicial process that it had seen in its years on the bench, as well as in private practice before the bench. And we have great respect for the business court. It's a place we practice in front of regularly, and we did not take this appeal lightly because we certainly admit that all parties would be better off if they would have been able to proceed to the normal orderly process of discovery and then a trial on the merits. But it is our position that the process used by the court below does not properly support the sanctions that were entered, and for that reason, we believe the trial court abused its discretion in rendering the second sanctions order and the connected monetary sanctions order. The standard of review before us today is an abuse of discretion standard, and we readily concede that it's generally a difficult standard to overcome because abuse of discretion orders are generally upheld unless it appears that the order was so arbitrary that it could not be the result of a reasoned and rational decision. However, that standard assumes that the appellant was fully apprised of the charges against him and given a full and fair opportunity to respond to those charges. That's constitutional notice that is required in connections with sanctions proceedings, and whether that notice was satisfied is a question of law. It's our position in this appeal that constitutional notice was defective in 2 respects. First, the trial court undisputedly considered new evidence that was submitted with a reply brief after the appellants had an opportunity to respond to the initial charges. And then second, the trial court improperly relied on evidence from a prior show cause motion that was never addressed in the motion for sanctions, and it was not properly incorporated into the second sanctions motion. Regarding the first grounds, the improper reliance on the reply evidence, there is no dispute that a substantial basis for the court's second sanctions order rested on findings that it made concerning a shadow Dropbox and a store and go thumb drive that had not previously been disclosed by the appellants. in the sanctions order, the trial court even said, of particular significance for purposes of the second sanctions motion are the use of the shadow drop box and that store and go thumb drive. In fact, when the court enumerated 16 ways that Fabian Ado had engaged in litigation misconduct, the majority of those examples came from the shadow drop box and store and go activity. And those findings are at the record pages 2377 and 2378. The problem, we contend, with the courts relying so heavily on that evidence is those were entirely new grounds from what the original motion for sanctions was based on. Red Valve's second motion for sanctions made clear that the motion was about something else. It made clear that the motion was about the use of 3 electronic files known as the preliminary injunction exhibits. And in fact, immediately after the second sanctions motion was filed, the trial court entered a preliminary order on those motions, and it confirmed that the motion was specifically about the use of the preliminary injunction exhibits. The shadow drop box and the store and go was new evidence submitted with the reply brief, and about that there is no dispute. Red Valve's own reply brief even said it changed what the motion was about. Red Valve called it new evidence and even said this new evidence was completely independent of what was in the original motion. And again, the trial court's second sanctions order relies so heavily on this new evidence that it's impossible to divorce it from the actual order. In other words, if this court were inclined to say, well, isn't there additional undisputed findings that could have supported a sanctions order? That's possible, but for the court to uphold the order on that basis would essentially be substituting this court's discretion for that of the trial court. And the relief we seek would be to remand this case for further proceedings on the second sanctions motion that follows a proper posture. Now, in Red Valve's response brief in this matter, they claim that appellants did not object to the consideration of that new reply evidence, and we submit that is not correct. The transcript makes clear that we did alert the court to this very issue. The Walsh v. Cornerstone case, I believe, had just come out the morning of our second sanctions hearing.
Mr. Durham, did you ever move to strike it?
We did not move to strike, Your Honor.
Does that make any difference in your view?
We believe it does, Your Honor. We believe that a number of the cases that Red Valve cites on a failure of a motion to strike and things of that nature are more regarding procedural notice cases. They're motions to dismiss. They are summary judgment motions. And we believe when we're addressing constitutional notice, which is a heightened standard, that our statements at the original hearing, as reflected in the transcript, are sufficient to raise the issue before the court. Again, in that
did you do anything else to object to consideration of this issue other than making the statements that you alluded to in the transcript?
Your Honor, no. We believe that the statements in the transcript are how we address the issue, and we believe those were sufficient.
Is your view that the trial court simply just doesn't have the discretion to consider this information at all?
For a sanctions order, Your Honor, I believe that is correct. It does not have the discretion to consider that evidence.
Based upon Walsh?
Based upon Walsh and cases requiring what we believe is a heightened constitutional notice requirement for a sanctions motion.
Now, at least, your memory of Walsh is probably better than mine. My recollection of Walsh is that the issue in Walsh was the imposition of sanctions on a different legal basis as compared to the imposition of sanctions based upon additional factual information. Is my recollection of Walsh faulty?
No, Your Honor, that is correct. It was the same facts in Walsh. The court at the hearing in that case on its own raised a different provision of Rule 26 and then elaborated on those grounds in its order. And the court there said that did not satisfy the notice. We don't think there's a difference whether the law gets raised later or additional facts gets raised later.
So there's no difference between facts and legal theories as far as you're concerned in your reading of Walsh?
That's correct, Your Honor, because the requirements are the party against whom sanctions are sought must be fully apprised of the charges against them. We believe that involves both the grounds, the legal grounds, and the factual grounds.
And the only time at which notice can be provided is in the initial sanctions motion, not in any subsequent filing that you don't move to strike.
That's correct, Your Honor. With regard, there are some of the cases cited by Red Valve. There were not sanctions motions to begin with. There were more procedural motions to dismiss, motions for summary judgment, and in some of those, there were additional grounds filed before a hearing, like an affidavit filed 2 days before a hearing. In those cases cited by Red Valve, the court permitted those. But again, those were not constitutional notice type cases. They were not sanctions cases. And even in some of the cases, like the Artistic Southern versus Lund case, which is one of the cases cited by Red Valve, the court accepted reply evidence on a summary judgment motion because it said it directly related to an issue raised in the response brief. And that's not what happened in this case. By their own admission, this was all new evidence that they submitted in connection with the reply. The trial court also erred by finding that Red Valve had incorporated facts from an earlier show cause motion into its second sanctions motion.
Before you go to the incorporation argument, can I just ask one other question about the new evidence argument? And given that you're basing this on the constitutional notice question, what significance is it that your clients received the affidavit? There's some unclarity in the record, but some 24 days before the hearing?
That is correct, Your Honor. There's no dispute as to the timing of the receipt. There was no provision for the reply evidence. For a surreply, we believe we would address this issue at the hearing, and we believe we sufficiently did, saying, Your Honor, it's important we make very clear what this motion is about. And we asserted that this was about the original preliminary injunction exhibits and cited Red Valve's own words from its original brief that this should be what the motion is about.
But I guess my question is, if the material was available some 3 weeks or more before the hearing, didn't that give you an opportunity to respond to the evidence that was in the affidavit?
In theory, though, our business court rules don't allow any surreplies. It would have required a party to ask for that leave, even though, again, there's no provision in our business court rules for doing that. It would have essentially required our clients to tread new ground and make up a new process and ground. And we believe we sufficiently raised the issue at the hearing. Another ground the trial court erred was by finding that Red Valve incorporated old evidence into its second sanctions motion. Specifically, the trial court ruled at the record, page 2372, that Red Valve incorporated those allegations into its motion. And these were allegations concerning Ado's contact of a customer, a use of a Red Valve design for a LinkedIn posting, and Ben Payne's possession and non-disclosure of a thumb drive. The court's finding that Red Valve had incorporated those allegations into the present sanctions motion is simply incorrect. Red Valve did not expressly incorporate those charges. All they said.
Mr. Durham, again, please excuse me. I have found over the years, if I don't ask when something occurs to me, there's a risk I may lose track. You've said you may, in the statement you just made, you made a reference to an express incorporation by reference. Is it your contention that in the absence of some formal statement to the effect that we hereby expressly incorporate X into our filing by reference, there's no incorporation by reference?
I believe, yes, Your Honor, for a sanctions motion that requires that the other side be specifically apprised of the factual basis for the charges against them. I think that something more is required than just saying plaintiffs refer the court back to plaintiff's prior motion for a full recitation of their truly reprehensible conduct. I don't believe that was sufficient, Your Honor.
Okay, and why not? Other than because it didn't contain a quote express incorporation by reference, close quote phrase.
I think it does not fully apprise the defendant that those old grounds are now the basis for new grounds, a new sanctions motion against them. It's our position that does not fully apprise the defendants of the charges against them on the present motion.
Okay.
The last issue I'll take before turning over to Mr. Davis is the temporary restraining order that was originally issued in this case. There was a provision prohibiting any of the defendants from contacting any of Red Valve's customers. Mr. Ado's subsequent contact of a customer was then used as a basis for the second sanctions order. We don't believe that provision of the temporary restraining order was proper, given that there was no non-solicitation agreement. That's undisputed. And there was no non-competition agreement. There was no basis for the trial court to enter a customer off limits type provision in the temporary restraining order. Red Valve contends that's not actually what the order said, that it was more limited to and connected to the use of trade secrets, but a plain reading of the trial court's second sanctions order makes clear that's not how the court interpreted its earlier ruling.
I mean, there's no question, is there, but that the order read literally was in effect at the time that one of your clients had the contact that's at issue there. I don't know. There's no question about that, Your Honor. And Red Valve is it then your contention that a party is not obligated to follow an order that he or she believes to be legally proper?
They would, no, it's not, Your Honor. And they would certainly do so at their own peril. And we would never counsel. But the Fiasco case makes clear, first of all, that was an interlocutory order. So there was no appeal from that at the time. Fiasco makes clear that when appealing a sanctions order, it brings with it the appeal of all the underlying orders on which that sanctions order was based. So our appeal now is proper as to the temporary restraining order. And it's our position that because that provision was invalid, that a sanctions order based on that should also be invalid. I'd like to turn it now over to Mr. Davis to address Ben Payne specifically. Thank you, Your Honors.
Good morning, Your Honors. My name is Ward Davis of Bell Davis and Pitt. And as Mr. Durham indicated, I'm going to be brief so we can save some time for rebuttal, but we do want to reiterate the importance of the court appreciating the difference between the positions of Mr. Payne and Mr. Ado. And Judge Bledsoe points that out himself. And speaking of Judge Bledsoe, I don't want it to go without being said I'll reiterate what Josh said. We do not take any of the issues in this case lightly. I have the utmost respect for Judge Bledsoe. I've been practicing in front of him since he took the bench. I think he's a fantastic jurist. None of this is taken lightly by us, but it's important to get it right because we are talking about constitutional issues and due process issues. And so it is important to look at Mr. Payne and Mr. Ado separately. The logic bit case that's been discussed in this case struck the answer of just some of the defendants, not all of the defendants. And so it is important to compare Mr. Payne and Mr. Ado. And if you look on pages 48 and 49 and the bottom of page 47 of Judge Bledsoe's September 3rd order, that's where the sanctionable conduct of Ben Payne is set forth. And in the Walsh case, I think the language of the Walsh case is important in looking at what the Court of Appeals decided needed to be done to get it right. And if this matter is remanded, that's why it's remanded. It's to get it right. It doesn't mean that the outcome necessarily is different, but we need to get it right procedurally and from a due process standpoint. And the Walsh case's conclusion, the Court of Appeals conclusion in Walsh, is this. Accordingly, in light of the lack of notice provided, we agree with the defendant that the trial court's order imposing sanctions for a violation of Rule 26E must be vacated and remanded. And here's why. For entry of an order that is consistent with the grounds upon which the plaintiff moved to strike the defendant's answer. And so the key is, and again, I'm here to ask you to look hard at Mr. Payne, is the order regarding Mr. Payne, and the order's taken as a whole, but principally focused on what Judge Bledsoe created a heading, Payne's sanctionable conduct. And does that sanctionable conduct match? Is it consistent with the grounds upon which the sanctions were sought against Mr. Payne? The other point I will make is to Judge Irvin's question about legal differences versus factual differences. And I would encourage the court to look at the Griffin case that's cited and quoted in the Walsh case. And the Griffin case is a Supreme Court case from 1998 in which the Supreme Court actually reversed the Court of Appeals. The Court of Appeals found that the notice was valid in the underlying case. What happened in the underlying case, it was an adoption proceeding, and a Rule 11 motion was filed against opposing counsel on the basis that the filing of the adoption proceeding violated Rule 11. And the court ended up finding that 10 other filings, rather than just the adoption proceeding, were the basis for sanctions. And in fact, the Court of Appeals apparently took a similar view of the fact that the lawyer was on notice that the legal basis was Rule 11. But the Supreme Court said, no, that's insufficient. And they even say, in describing why they disagreed with the Court of Appeals ruling, the Supreme Court says, the Court of Appeals held that Mr. Henderson received adequate notice of the sanctions to be imposed against him. This is so, said the Court of Appeals, because Mr. Henderson had full notice that he was under consideration for Rule 11 sanctions, the legal basis. The district court issued a detailed order reciting findings of fact informing him why the sanctions have been imposed, and Mr. Henderson fully participated in the hearing at which the sanctions were imposed. And the court ultimately held that none of that was sufficient to give adequate notice because of that change in what was really the factual basis. Instead of one filing, it was multiple filings that the court decided to impose those sanctions, and the Supreme Court found that that was improper. And we'll save the rest of our time for rebuttal. Thank you, Your Honors.
Thank you, counsel. We'll hear from the appellee.
Thank you, Mr. Chief Justice, members of the court. May it please the court. For 12 long and expensive months, these defendants repeatedly violated more than 5 trial court orders on over 75 occasions that were intended to preserve the status quo of the parties so the parties could litigate the merits of the case. Judge Bledsoe patiently and repeatedly attempted to steer these defendants into compliance with his orders so the parties could proceed to the case on the merits. But defendants violated those orders at every turn. This case is not a case where there was a rush to sanctions on one motion. It's not a case where there were mere technicalities or procedural faults. It's a case where the defendants repeatedly violated Judge Bledsoe's orders that went to the heart of the trade secret case and the core of the court's authority to ensure the administration of justice. Defendants, Judge Bledsoe made this reasoned decision based on all of the evidence that was presented to him without objection at the trial court level. And he reached his conclusion after listening to all of the arguments, which include none of the arguments that were made to you today. Judge Bledsoe's decision came long after this case started. The case started when defendants began collecting and storing Red Valve's trade secrets while they were still employed at Red Valve, so they could start a business directly to compete with Red Valve. When Red Valve caught the defendants, they terminated them and filed this lawsuit in March of 2018. Judge Bledsoe entered a temporary restraining order and then a preliminary injunction to preserve the status quo. Judge Bledsoe's preliminary injunction dealt with many issues, but 2 are important to this appeal. First, Judge Bledsoe said the defendants were enjoined from having or using Red Valve's price book, which Red Valve used to price its products. Judge Bledsoe said the defendants were enjoined from having or using Red Valve's build sheets, which Red Valve used to build its products. And then Judge Bledsoe said the defendants had to return the property that they had stolen from Red Valve on the way out the door. These 3 orders started the case. The defendants violated those orders and others starting in March of 2018, the same month this case was filed. They violated the orders in April 2018, May, June, September, October, November, and December 2018. They violated the orders in January, February, March, April, and July of 2019. All discrete violations of multiple court orders, while Judge Bledsoe was holding hearings and issuing other orders attempting to steer the defendants into compliance short of striking their answer. Defendants refused to ever come into compliance. We've laid out on page 4 of our brief the statement of the case that walks through each one of defendants' separate violations, the majority of which are binding on the court because they're findings of fact the defendants have not challenged. While defendants appeal 12 orders, they find fault in only one of those, which is the second sanctions order. And within that order, they only challenge 2 findings of fact.
Well, what did Mr. Chestnut, the interchange I had with your colleagues, suggested that they also contend that they are challenging a provision in the initial TRO. What's your response to that in light of the statement that you just made?
Your Honor, they haven't challenged the findings of fact in the TRO. They have challenged that the TRO is overbroad. But
and at least if I understood your colleague's argument, he was saying in effect that we have the right, given that this was a preliminary, was a temporary restraining order, therefore an interlocutory order or an appealable order, to seek appellate review of it now, and that's what we're doing. That's my words and not his, but I hope that's an accurate summary of his argument. What response would you make to that?
And Your Honor, Mr. Allen's going to respond to that part, but what we would respond is that the order could have been challenged at the trial court level under Rule 65 for a motion to reconsider. Instead, the defendants agreed twice that it should be extended for further periods of time. They never raised the arguments they raise now, and it's improper to raise them as a basis for overturning the second sanctions order. And then finally, given that Mr. Ado violated court orders on 61 occasions, even if you take out the TRO violation, striking his answer is still well within Judge Bledsoe's discretion. I think as a summary of what Mr. Allen's going to argue to you.
Well, I assume if Mr. Allen wants to say anything else, he will feel free to do so.
Your Honor, again, I think it's important to understand how we got to the second sanctions order because it was not a rush to sanctions. Judge Bledsoe 3 times ordered the defendants to return Red Valve's property that they had taken on their way out the door, and defendants never did that. So he ordered the parties to engage in a return and preservation protocol that took 7 months to negotiate and required at the end of it that the defendants certified that they no longer had Red Valve property. After the court entered the return and preservation protocol, defendants violated its deadlines, did not return Red Valve's properties, and then filed false certifications under oath that they had returned Red Valve's property. Those false certifications allowed defendants to keep Red Valve's property, which they used to access Red Valve's trade secrets to compete with Red Valve during the pendency of the litigation in violation of the preliminary injunction. As another example of their violative conduct, Payne went to a Red Valve employee's house and solicited that Red Valve employee to give him thousands of Red Valve build sheets after the court entered the preliminary injunction and joining him from having or using those build sheets. They don't dispute that fact on appeal. That was the subject of Red Valve's motion for show cause, which it incorporated into its second motion for sanctions. And then there was Red Valve's first motion for sanctions, which arose because the defendants manipulated text messages to take out admissions that they had used Red Valve's trade secrets to form their own documents. They literally manipulated text messages so that lines of admissions weren't produced as part of the discovery in this case. Even with that really gross discovery abuse, Judge Bledsoe still did not strike defendants' answers. Instead, he ordered defendants to go through a forensic protocol to ensure that they had produced responsive documents and returned Red Valve's property. That forensic examination ultimately led to the second sanctions motion. First, the defendants violated the first sanctions motion by not actually participating in the forensic discovery in full. But what they did give in the forensic discovery showed that the defendants were using preliminary injunction exhibits that were filed under seal and the defendants should have never had access to access Red Valve's price book on over 40 different occasions, to use Red Valve's price book to price defendants' products. Mr. Durham said that the reply evidence didn't address anything raised in response, and that's just not the case. In response to Red Valve's motion for sanctions based on the forensic data, defendants conceded that all of the forensics data was true. They instead said, oh, we only use these preliminary injunction exhibits because our lawyers provided them to us. Well, in reply, Red Valve submitted evidence through forensic experts and argument that in fact the defendants had used this price book through other means that they did not receive from their lawyers, directly refuting an argument defendants raised in response. That evidence was all submitted 24 days in advance of a hearing. Defendants never objected to the evidence. They never moved to strike the evidence. They didn't ask for a continuance of the hearing. They did not ask for a surreply, which is not an uncommon procedure that you would have to plow ground to get. Instead, they showed up to the hearing and they said, quote, we decided instead of filing a surreply, we figured Your Honor would ask about it and we would address it the way we are right now. That's what defendants did in response to the evidence they received 24 days in advance. Judge Bledsoe considered that evidence, considered those arguments, and issued his order.
Can I just ask one thing that I couldn't tell clearly from the record? So why wasn't the Walker affidavit from May of 2019 supplied with the original motion or supplied earlier?
Your Honor, it's because it directly refuted arguments that defendant raised in response. In our original motion, we submitted evidence that defendants had used on over 40 occasions Red Valve's price book through their preliminary injunction exhibits. In response, the defendants argued, well, we got those preliminary injunction exhibits from our lawyers, so we thought we could use them. Judge Bledsoe found that explanation not credible on basis in our original motion, but we included reply evidence that showed that they had used the same price book through means other than the preliminary injunction exhibits that they did not receive from their lawyers. So the reply evidence directly refuted an argument that defendants raised in their response. Defendants now claim they didn't have notice of what they said at the hearing that they figured Your Honor would ask about. And they've conflated two different notices, procedural notice and due process notice, doing what I believe my mom taught me and probably your mom's taught you, that two rights don't make a wrong. These both bases are wrong. The procedural one is easier to deal with. Procedural notice, as required by things like Rule 5, Rule 6, Rule 7, Rule 56, that's easily waived. If a party participates in a hearing without raising procedural objections, they've waived them. I believe Judge Irvin addressed this when he was on the Court of Appeals in a case called G, and that rule has stood the test of time. So any sort of procedural arguments defendants now make, they have waived. The constitutional notice is wholly separate from procedural notice, as the court held in Raintree v. Roe. It is based on a single question, not how the evidence came in, which defendants argue now, but when defendants received the evidence. And so long as defendants received the basis for the sanctions against them before a hearing where they had an opportunity to respond, constitutional notice is satisfied. There's no heightened requirement. It is not on top of procedural notice. It is wholly separate, and the standard is just whether they received the notice before a hearing where they had an opportunity to respond. Red Valve moved for sanctions on three bases. They moved for sanctions on the basis that the defendants had used Red Valve's trade secrets during the pendency of the litigation in violation of the preliminary injunction, that they had filed false certifications that allowed them to keep the trade secrets, and specifically that Ben Payne had filed false certifications on behalf of himself and Titan Valve so that they could keep those trade secrets. And then third, that the entire history of the case justified striking the defendant's answer. Defendants had all of that evidence and all of those arguments 24 days in advance of the hearing, which is 5 times more than our rules of civil procedure require for a similar motion for sanctions if it would have been filed under the rules of procedure. So defendants had notice of the reply evidence. It was sufficient. Defendants also argue that the court can't consider the case history, and their argument here fails for 2 reasons. First, there's no magic words test for incorporating prior conduct into a motion. The question is whether, as defined in Walsh in a footnote, the defendants had indication that the conduct would be used as a basis for sanction. Red Valve devoted an entire section of its opening brief to the allegations in the motion for sanctions and its motion for show cause. The parties had been litigating those very violations for nearly 12 months straight at that point. It would defy logic that Red Valve included that reference in its brief only to leave those allegations out, which were core to the case at that point. Second, Judge Bledsoe found an alternative basis to consider the case history. He relied on the Greer case and the Patterson case to find that he had the authority to consider the case as a whole. Defendants have not challenged that conclusion of law on appeal, and it was an alternative basis for the court to consider the show cause motion. It's therefore, since defendants have not challenged both bases for Judge Bledsoe's consideration of that material, their appeal necessarily fails. Finally, defendants have claimed, although it doesn't appear that they've argued it today, that somehow Mr. Payne was confused and he didn't know default was sought against him. However, Judge Bledsoe did consider that argument below and held in paragraph 74 that that standard was easily met as to defendant Payne. Red Valve's motion stated in its original motion that it sought to default all defendants and strike all defendants' answers. In his reply brief, Ben Payne said that he understood that defendants sought to strike, or plaintiffs sought to strike all of the defendants' answers across the board. And at the hearing, they acknowledged that as well. Mr. Payne knew default was sought against him, but he sat silent. He didn't contest at that point that his certification was false, nor did he challenge the show cause motion, which was briefed and argued months before and then could have addressed again at the hearing. To Your Honor's point, Walsh is wholly different. Walsh involves a case where there was a motion for sanctions based on Rule 26G, which involves the certification signed when discovery responses are served, and the court sanctioned that party under Rule 26E, which involves the supplementation. This case is different because it involves 12 months of conduct that was the subject of multiple motions along the way and the building of a record that culminated in a second motion for sanctions where Judge Bledsoe said, I've tried to bring you into compliance multiple times. I've offered you multiple opportunities where you could comply with my orders and we could proceed on the merits. But you've left me in a position where default is the only available remedy to protect these plaintiffs and protect the judicial system as a whole.
When I've discussed Walsh with your colleagues, he directed my attention to Griffin. I mean, I've heard his view of Griffin. What's yours?
Griffin is a different case. Griffin involved an adoption petition where a Rule 11 was suggested for the adoption petition, and then the court, on its own motion, separate from the motion before it, sanctioned the party for other pleadings it had filed in the case. There was no reference to those pleadings in the motion, unlike the case here where you have reply evidence that was submitted 24 days in advance and an entire section of the brief that addressed other motions that the parties had fully briefed and argued before in the case.
So your distinction, you would distinguish Griffin on the basis of essentially the amount of time that was made available to the party being sanctioned?
Right. I think it goes back to what the due process standard is, which is, did you know the allegations against you before you had an opportunity to respond to the hearing? And in Griffin, they raised those pleadings, not at the hearing, but I believe afterwards on the court's own motion. And here we raised them 24 days in advance through a reply brief. I do believe, Your Honor, they are separate cases. If we had submitted the reply evidence at the hearing for the first time, this would be a different case. Instead, we submitted it 24 days in advance, and the defendants, quote, decided instead of filing a reply brief, we figured Your Honor would ask about it, and we would address it the way we are right now. What defendants would have this court do is do one of two things: either impose procedural requirements on due process notice, which courts have never done, or impose magic word requirements on due process, which courts have never done. The issue is not what the procedure was used under the Constitution or what words were used for constitutional notice. It is whether there was an indication prior to the hearing that the defendants would be asked about the conduct that is the basis for sanctions. And that standard is easily met in this case. Even if the defendants, I'll say this, defendants have also waived all of these arguments. While they say they raised concerns at the trial level below, Rule 10 of our appellate court rules requires a specific objection and a ruling. What they did at the trial court below is the exact thing that Rule 10 is intended to prevent. They sat silent, allowed the court to consider evidence, and now object to it when they don't like the result. This is not a case where they were caught off guard at the hearing. Defendants made a deliberate strategy below to ask for forgiveness rather than explain their conduct. They could have used a surreply to address the allegations. They could have shown up at the hearing and argued that their conduct, that these forensic reports were wrong, or that our allegations were wrong. They made a strategic and intentional decision not to file a surreply and instead to show up and ask for forgiveness, for the court to impose lesser sanctions. That strategy didn't work for them, and now they want a new strategy on appeal. And that's exactly what Rule 10 prohibits. So these arguments are all waived, and the court shouldn't consider them anyway. Finally, there is no prejudice in this case. Mr. Davis says that if you send it back down, Judge Bledsoe will do the same thing. Judge Bledsoe said that this was the most open defiance of law he'd seen in his 30 years as a judge or a lawyer. He said it's the worst disregard for the judicial process that he's seen in his 30 years as a judge or a lawyer. There's no prejudice in this case because even if you take out certain parts of the motion, other parts remain true and unopposed and support striking the defendant's answers, or at least leave it within the court's discretion as to what sanctions should be imposed. For instance, defendants say that they shouldn't consider the show cause motion, but defendants don't challenge any of the court's factual findings related to the show cause motion. They don't challenge that Ben Payne actually went to a Red Valve employee's house. They don't challenge that he asked them for build sheets. They don't challenge that the preliminary injunction had been entered at that point. They don't challenge that the preliminary injunction was clear that he couldn't have those documents. What would they have done with more time? That's the question for prejudice. And would it be any different going back on below? What testimony would they offer? What evidence would there be to make the result any different? And for Ben Payne on show cause, there is none. I think that we've quoted Judge Bledsoe's opening line when he issued his order orally at the hearing, and I believe that is important for the court to consider just how bad the abuse is. But also in paragraph 118 of the court's order issuing sanctions, Judge Bledsoe summarizes what's happened in this case by saying at every turn, the Titan defendants have shown a complete disregard for the legal process and the administration of justice. And the court concludes that the severest sanctions are necessary and appropriate to address their misconduct and protect the integrity of the judicial process. That decision is one we leave to the trial courts to consider based on the record before it, because they've been with the case the longest. In this case, Judge Bledsoe was with it for 12 months straight, and they know what sanctions are appropriate. And this court respectfully should not impose its own judgment or Judge Bledsoe's judgment in determining what sanctions are appropriate for the worst disregard of the judicial process that Judge Bledsoe had seen in 30 years. Mr. Allen is going to address the temporary restraining order and Ben Payne's certification. Thank you, Your Honors.
May it please the court, Mr. Chief Justice, members of the court, I'm David Allen. And as Mr. Chesson said, I will address the final two assignments of error that the defendants have raised. Those are the issue with respect to Mr. Ado's TRO violation and with respect to Mr. Payne's false certification. First of all, with respect to the Ado TRO violation, Mr. Ado never challenged this TRO or its breadth down below. He had opportunities to do that. In fact, he consented to 2 extensions of time for the TRO. He also never filed a Rule 65 motion seeking to either dissolve or to modify it. We think those were proper ways to get whatever review he wanted to of the breadth of the restriction that was imposed upon him by Judge Bledsoe. But they didn't ever assert that. This is the first time that we've heard that they thought the TRO was overly broad. And they say it prohibited all contact with customers. That's not accurate. If you look at the order itself, it prohibits contact with customers named in the plaintiff's trade secrets. This later became known as the red valve or the customer database. You'll see that reflected in the preliminary injunction. You'll see other references to the red valve or the customer database in subsequent orders from Judge Bledsoe. That's the same thing as the customer identifier of the trade secrets, and that in fact, that customer database was one of the 5 trade secrets that Judge Bledsoe found and that were designated to be saved. What he tried to do was to craft a TRO that did exactly what TROs are supposed to do, which is to preserve the status quo. However, forecasting Titan defendants' future actions, Mr. Ado went out and violated the order the very next day by contacting the customer and saying, I've left Red Valve, I'm starting my own business, don't order from them. I'll be back in touch with you when I get my new business up and running. That's the conduct that he did. Mr. Ado doesn't deny this violation. In fact, he subsequently admitted the violation in an affidavit filed with the court. But even if the order was too broad, which we do not concede in any way, but to pick up on what Justice Irvin said, it's still entitled to be enforced. It's still entitled to, it is a valid order. This is not a void order. This is an order that is only potentially voidable. And defendant took no steps to test the validity of that order. And as such, it was a valid order that was entitled to be obeyed. Even if a TRO is improperly granted, a litigant can't just decide, as this court has said, on a whim, that's the term this court has used, to violate that order and not expect to have that come back to bite them as it did in this case. It was an order of the court and a valid order and entitled to be obeyed. Next, moving to Payne's false certification. In February of 2019, Payne swore that he had no red valve property remaining in his possession. In reality, he had numerous computer files that belonged to Red Valve. Judge Bledsoe found that Payne was not credible in this assertion. And case law says that a court's decision with respect to credibility is conclusive if supported by competent evidence. And certainly there's an enormous amount of competent evidence to support that finding right here in this case. Payne filed no affidavit or anything to dispute the assertions that were found that he in fact did still possess Red Valve property. When confronted, what did he do? He sat mute, made no argument, filed no paper, filed no affidavit contesting the fact that he still had this property. Many of the computer files that were found had the word Red Valve in the title. So he can't say that he didn't know. These were computer files he took that had the word Red Valve in them that were displayed on his devices. Now, in their brief, the defendant seems to say that there was only one device that contained this offending material. That's not true. This material was on several devices that were controlled by Mr. Payne. Mr. Payne has tried to blame counsel or to blame Invista for this violation. Invista being the forensic group that he had retained to help with the protocol, the return and preservation protocol. But as the court found, Mr. Payne had not submitted all of his devices to Invista. And that even putting aside the Payne individual affidavit about what his individual devices contained, Mr. Payne also signed a certification that Titan had no Red Valve property on any of its devices. And that's demonstrably false. Payne swore that Titan provided all of its devices subject to the return protocol and that Titan was not aware that any Red Valve property remained on Titan devices. And that's just false. Judge Bledsoe found that Titan did not provide Mr. Ado's laptop to Invista. That allowed Ado to retain and use the preliminary injunction evidence, which Mr. Chesson told you about, to compete with Red Valve. This is where he went to the Red Valve price book, checked the price, closed the Red Valve price book, and offered an order, or a bid rather, for a subsequent vendor. I think this happened from Judge Bledsoe's order over 40 times. This is the material that was contained in Mr. Ado's laptop and in other places. Titan also retained these preliminary injunction exhibits, the price book and the other trade secrets that we were complaining about, on Mr. Ado's email and on Mr. Payne's Titan email. And those accounts were open for months, never submitted through the protocol, and Payne swore and certified that Titan did not have this information. That was incorrect. In finding 57, Judge Bledsoe found that at the time of the March 5th certification, the preliminary injunction exhibits remained on Payne's Titan email account and on his Lenovo device. At 127, the Titan defendants failed to identify at least 4 devices or accounts that contained that retained the prohibited material. These arguments that defendants raise here are all barred by waiver, as Mr. Chesson said. More importantly, they are barred by prejudice. Because what the standard is, it's not just that you were negatively impacted by a court's ruling, but a but-for test. And but for that ruling, you would not have been subject to sanctions. And that's not the case here. The defendants have not even tried to tell you that, well, if I had not been cited for violating the TRO, my answer wouldn't have been struck. If I had not been cited for filing a false certification, my answer would not have been struck by Judge Bledsoe. That's not the case. They must prove to this court that they suffered prejudice, which means they would not have suffered the harm that they suffered but for these rulings. This case demonstrates the true value of the business court. Judge Bledsoe had this case from day one. He saw the case evolve. He saw what defendants did while they were still our employees. He saw them violate his orders time and time again. He saw them and admonished them to come into compliance, and they refused. He gave them plenty of time to get their house in order, and they chose not to do so. And ultimately, when faced with this terrible disregard,
Mr. Allen, I'm sorry, but it appears your time has expired.
Thank you, Your Honor. Appreciate it, Mr. Chief Justice, members of the court.
Mr. Durham, you're muted.
Sorry for that. Just a few points on appellant's rebuttal. We certainly do not relish going back before the trial court for further proceedings in a sanctions motion, but we do contend it is important to get the process right, not just for this case, but for future cases, and to address some of the gaps and sanctions and reply evidence questions that have been raised during this proceedings. A point was made about the temporary restraining order by the appellees. I believe the statement was that even if the temporary restraining order part was set aside, there is still plenty of evidence before the court on which the trial court's decision could be sustained. We submit that is not the proper result, because again, that would be substituting this court's discretion for the trial courts. We don't know how large certain segments of those findings loomed in the court's ultimate ruling.
Are you then suggesting that there's no applicability of the harmless error doctrine in this type of case?
I don't believe there is on a sanctions motion, Your Honor. There was certainly no discussion of that in Walsh. I would contend that Walsh probably was going to face or Cornerstone was going to face a similar result on remand, just citing to the proper legal rule. But there was no discussion of prejudice or a different result in the Walsh case, which I think confirms our position about just how important these notice provisions are. There was discussion about the trade secret customer non-contact order, that it was supposedly limited to using a customer database. That's just not the case. The trial court at page 2361 of the record found that Ado knew he could not contact a customer. That's straight out of the sanctions order. That makes clear that this was a blanket customer non-contact order. It was not confined to using trade secrets. There was no finding that Ado ever used a trade secret to contact that customer. It said he contacted a customer, and that was a violation. Justice Earls, I believe, asked about the Clark-Walton affidavit and why that was not available when the original motion was submitted. And the response was that the evidence in that affidavit about the preliminary injunction exhibits was used to directly refute statements made in the response brief. But wholly absent from that answer was any explanation about the new shadow Dropbox and the thumb drive evidence, which again was characterized by Red Valve in their reply as new evidence. And when there was not any explanation from Red Valve about why that information was not available, and nor was there a contention that that directly refuted anything in our response brief. Again, we contend that was new evidence. A few final points. There was reference to the Greer v. Patterson case and whether a trial court could consider the totality of circumstances, and maybe that's what brings that old evidence properly before the court. We submit that a reading of the Greer case and the out-of-the-box case make a distinction between considering violations of prior orders, which is what went on in those cases, and those you could properly consider. I've already sanctioned you once for this particular conduct. Now I've got another sanctions motion. I can consider the fact I've sanctioned you before, but that's not the evidence that the court considered here. There was never any ruling on the old show cause evidence that the court then brought into this current second sanctions motion. So, Your Honor, Your Honors, for the reasons stated in our papers and here today, we would ask that the court reverse the trial court's second sanctions order, along with the associated monetary sanctions order that was imposed shortly thereafter that. Thank you, Your Honors.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now in recess. God save the state and this honorable court.